Afternoon. I'm also very happy to be here. I'm talking about trademark and design registration strategies in Europe. The goal of this presentation is to show that there are some systems, some registration systems in Europe, and particularly in European Union, that might be very useful and interesting also for outsider from outside the world, and particularly from India. First of all, I will give you some statistics. I don't want to bore you, but I hope you find them quite interesting, and we can better see what we are talking about regarding facts and figures. Then I will spend a few words on trademark registration strategies and move on to the design registration strategy and show you some examples of how efficient designs can be. So some statistics in general. Europe, it's a continent in green, 50 countries for less than 800 million people, a lot of smaller countries, and you would say, okay, it might be awful to get protected rights in such a continent. But it's very interesting because it's quite rich and it's a huge market. We have the European Union. It's the second map. It's dark green. There are like 27 countries with 500 million people, and it's quite interesting because it's the largest single market in the world in terms of purchasing power. So quite interesting for worldwide companies. And Europe is trading with India more and more. The EU, for instance, is the largest trading partner of India and absorbs 20% of all the exportations of India. And there are like 80 billion US dollar in products and services exchanged each year between Europe and European Union and India, and this figure is increasing with India becoming a world economic power. So if you look now at some statistics, and I took the statistics of the European Union, of the Trademark and Design Office, because one thing the EU is good at is statistics. They have statistics for everything. You think the community trademark application in total since 1996 is more than 1 million, as 1,150,000. 1/3 of this application come from outside the European Union, 365,000 applications, and 200,000 from this application come from the USA, from Japan nearly 30,000, from China 16,000, and from India only less than 2,000. So we see that the importance of the European Union for Indian exportation has not been reflected yet in the trademark registration by Indian companies. Look at the statistic for designs, and the European community design is from 2003. So we have almost 700 design applications. From outside the EU, 155,000. From the US, 55,000, from Japan 33,000, from China 18,000, and from India 524,000. So looking at the statistic, we see we have a long run to make community trademarks and designs more palatable for Indian holders. So let's try to do it. If you see the community trademark system, I will show you some advantages of this system. You have a single right applicable in all the 27 member states of the European Union. And single right means single application and registration procedures, so which leads to huge cost reduction. The official fee for a trademark, community trademark now is less than 1,000 euro, which means 70,000 Indian rupees. But you also have huge advantages, not only in the registration proceeding, but also in the enforcement. With a community trademark, after a 5 years grace period, you have use requirement, and the use in one country of the European Union is sufficient for maintaining the right in the whole European Union. Then you have a very efficient administrative enforcement procedure against younger application, opposition procedure before the trademark office. It costs only 350 euro. Then for the judicial enforcement, you have specialized courts in each member state And coming from a country where there's no specialized court in trademark matters, it's very important to have specialized courts. And you may have judicial enforcement of judgment rendered in one country in the whole EU. If you sue a defendant at its seat or a country of permanent establishment, you can then have a judgment enforceable in the whole EU. And it's very useful also for customs surveillance. With a community trademark, you can make a customs surveillance application in one country of the EU, we then expand it in all the 27 countries of the EU. And it's very, very important for fighting counterfeiting and seizing the counterfeiting goods at the border. There are also some risks with the community trademark. The highest risk is that there are more potential conflicting trademarks because all the national prior rights are taken into consideration for the examination and the enforcement of community trademarks. There are also one single cancellation action, but I looked at the statistics. There are only like 1,000 European trademarks that have been declared invalid because of cancellation action. So the highest risk is more potential conflicting trademarks, but that risk can be mitigated with a good clearance beforehand. So I wouldn't recommend applying for a community trademark before having done a good clearance search. There's no alternatives to community trademarks, I would say. The only alternative is national registration, especially from Indian user. So if you want to have national application in all the 27 European Union states, it might be awful. There are only a few main European countries that are not part of the EU. I would say Switzerland, Norway, and former Yugoslavian countries. So you can get a protection, broad protection on all Europe, on the continent, with a European trademark application, and Switzerland, Norway, and maybe some former Yugoslavian countries. The international trademark, India has signed and ratified the Madrid Protocol for the international registration of marks. I think it's going to come into force in the next couple of years. Then it would be very useful for Indian holders. With one single application, you can have you can have many countries, but it's only one single application. The registration procedures is different for every country. So it's every designated country will still have its own examination procedure, which means it's a bundle of rights. It's not a single right as the EU trademark is. The advantage is that the EU can be designated with international trademark. So let's move on to the design registration. As Clive said, it used to be the Cinderella of IP right, but it can be very efficient. It gives a prima facie registered right, also for technical component, but it protects the appearance of the product. And with no use requirement, you have this right for 25 years. It's not very cost intensive, and the scope of protection might be quite broad. I picture an example. You see on the right, it's a combustion engine for lawnmower, I think. On the right, it's a younger application registration, and based on the picture on the design registration on the left, the owner made a cancellation action against the younger application, and the European Court of Justice, first instance, found out that the overall impression of these two designs was similar. If you look at them, you can see quite a lot of small differences, but anyway, the European Court of Justice said the overall impression, which is important and which is determinant, is similar. So, if a design, you can have a quite broad stroke of protection, and not only for one-to-one copies. Then you have the same advantages as for European community trademark. You have a single right applicable in all the 27 member states, single application registration procedure, cost reduction. A design cost 350 euros for protection in all the EU. You also have specialist courts, judicial enforcement of national judgment in the whole EU, and custom surveillance also based on design is possible. I'll give you an example of how efficient design could be. It's Clive mentioned in UK the proceeding Apple against Samsung It's part of the worldwide warfare between these two companies. And in Germany, in August 2011, Apple, based on its community design registration, pictured on the left, sued Samsung and tried to ban this Galaxy tablet. I think it was a 10.1 model of Samsung. And he got a preliminary injunction from the District Court of Düsseldorf. And the preliminary injunction was then confirmed in ordinary proceeding. Then it went on the second instance, and in the second instance they said, okay, they adopt on the validity of the community design, but there are some infringing action based on the law against the Act Against Unfair Competition, so I ban this product. The story is the ban was in the end only for Germany because it was based on unfair competition. But in the first step, if Apple hadn't had a design application, I bet that Apple couldn't have the preliminary injunction in the first place, because German courts looked very much at this registered right. Like here, staying with Apple, Samsung, a little joke. See, Your Honor, if I step away 10 feet and squint at both of them side by side, this fridge looks a whole lot like the iPad. One could easily, and the judge saying, granted, this fridge is now banned. It might look like a joke, but it's not a joke, because in design, right, you have no specialty principle. So it means it's only the overall similar appearance. If I have a fridge that look like an iPad, as an iPad owner, a design owner, I can ban the fridge. So, in conclusion, I would say registration procedures in Europe are not as complicated as often thought. The cost can be held relatively low and very low. And trademark and design are powerful weapons, tools, and shields. But there is one major risk, is risk of being too late, because the competitor do not wait. And it would be my conclusion, please do not wait. Thank you very much for your attention.